Hi, my name is Alexandra Austin. As an attorney in Nexen Pruitt's Business and Commercial Litigation Practice Group, I advise clients on complex civil litigation matters, including business and commercial disputes, multi-district litigation and class actions, and eminent domain and condemnation matters. Condemnation actions present a unique set of legal issues for landowners and land developers. Condemnation is the right of the government, be it federal, state, or local, or certain agencies who are statutorily vested with such power, to take private property for public use. With the rise in infrastructure projects in South Carolina, there are more and more of these so-called takings occurring throughout the state. And with the rise in property values in many areas, more and more of these actions are being contested by landowners. Usually, the challenge is not to the government's right or authority to take the property, but is instead focused on the amount of just compensation owed to the landowner. When the government decides to acquire private property rights for a public purpose, it is required to obtain an appraisal of the landowner's property and to make a reasonable and diligent effort to negotiate a settlement with the landowner regarding the amount of just compensation. While the government is required to make its appraisal available to the landowner, it is often advisable for the landowner to obtain their own appraisal of the property. This is because the government's appraisal may not account for the full fair market value of the property prior to the taking. For example, it may value the property based upon its current use and not the property's highest and best use, or it may fail to capture the value of land improvements. Or the government's appraisal may not fully account for damages to the property after the taking. For example, it may ignore damages to an unencumbered remainder of the property or fail to account for the impact of diminished road frontage or access. These factors can significantly impact the amount of just compensation owed to the landowner. Another issue unique to condemnation is the so-called threat of condemnation, where the government has made some indication of its future intent to acquire a landowner's property for public use. This can happen months, years, or even decades before condemnation actually occurs. Pre-condemnation strategy is key in these circumstances to not only protect the landowner's legal rights, but also to inform crucial business and financial decisions concerning the landowner's development and use of the property. Nexen Pruitt has successfully represented clients on many complex condemnation issues. If you have questions or need assistance in a condemnation matter, Nexen Pruitt's litigation team is here to help.